It's time for us to start, and we've also formed a quorum. I now call the meeting to order. Please invite the officials to come in. Welcome, government officials. I won't introduce them one by one. We're all very familiar with them. We've received a number of papers, including a paper tabled today. That is the administration's response to follow-up actions. In particular, the maintenance and restoration works for Tat Tak Communal Hall and Phat Tat Tong, as well as the sums of money involving Phat Tat Tong. And there are some private documents, which is an agreement signed by Phat Tat Tong. The AAB also wrote to us, and the administration can explain that to us. The conservation policy review is underway, so the AAB will not attend this meeting. Later, the AAB will report to the development panel of the ELECHCO in relation to the review of the conservation policy. So I'll hand the floor over to the government representatives so that they can take us through the latest progress. Who will speak, Ms. Ko or Mr. Ming? Perhaps I should speak first. We had a meeting on the 14th of January, and a list of follow-up actions was passed to us, and we've sent you a written response. So let me highlight the major concerns to you. First of all, members were concerned about the maintenance and restoration works for Phat Tat Communal Hall and Phat Tat Tong. In 2014-2015, the AMO will arrange a condition survey and prepare a conservation plan for the building in 2014-2015, with the restoration works to be conducted in 2015-2017. And for Tat Tak Communal Hall, upon completion of the restoration works, maintenance works will be carried out on a need basis. And then an agreement has been signed by the owner of Phat Tat Tong. And the opening hours of Phat Tat Tong, insofar as the common area is concerned, will be daily from 9 a.m. to 1 p.m. and from 2 p.m. to 5 p.m. And then it will be closed on Tuesdays, Christmas Day, Boxing Day, New Year's Day, and the first 3 days of the Lunar New Year. Display boards and guided tours would be offered to allow members of the public to appreciate the features of the monuments. And that will form part of Pingshan Heritage Trail. Members of the public would like to visit the monuments and historic buildings, but the best use of such buildings is the use they're designed for. If Phat Tat Tong is to continue to serve as a residence for the descendants of the Lee family, that would be the best choice. We respect private property rights, so we should strike a balance between that and conservation. So it's only under very exceptional circumstances, that is, when monuments and historic buildings are threatened by demolition and redevelopment, that the government will seek consent from the owners to obtain the titles to such monuments and historic buildings. All along, we've been encouraging private owners to open their monuments and historic buildings for public appreciation. As for Phat That Tong and Tat Tak Communal Hall, if members have any questions, we're happy to answer them. Our legal advisor reported to this panel that he has no new comments on the notice. Any new comments from the administration? No? Then I'll open the floor to members for questions and inquiries. Mr. Yu Si-wing. Thank you, Mr. Chairman. The information received this time is clearer than those we received at the last meeting. For Grade 1 monuments and historic buildings, are the basic arrangements the same in relation to maintenance costs, opening hours, cleansing and security arrangements? Are these the same as before, and in future the same arrangements will apply? Or are you making special arrangements for Phat That Tong as a result of our questions? Well, it depends on individual buildings. The costs may vary. As for the opening arrangements, they're basically similar to other monuments and historic buildings. For example, in terms of cleansing and security. So, opening hours up to 5 p.m. for all statutory monuments. No exceptions? Well, unless special arrangements are required, for example, when the structure is within a restricted area, then we may need to make special arrangements. What about Christmas Day and New Year Day? Are the arrangements the same? After considering the staff stationed there, well, basically they are the same. That is to facilitate public understanding so that they can grasp the opening hours better. Christmas Day always closed? Well, basically the structures will be closed once every week. Well, I just want to make sure that these are not special arrangements for Phat That Tong. As for guided tours, as mentioned last time, would like the descendants or the villagers to be responsible. If you are to fetch somebody else to do the job, we have to consider that the location is rather remote. So have you ever considered the qualifications of the docents? Well, we'll conduct an open recruitment exercise for docents. It's only after training that docents would be arranged to be responsible for the guided tours. If the villagers or even the owners are interested, we of course welcome their participation. But during the training period, we usually ask the owners to provide relevant information to us. And sometimes owners are interested in serving as docents. We of course welcome that. So there's a mechanism for them to participate. Yes. As for the arrangements mentioned by you, be it guided tours or opening hours, have you discussed all these aspects with the owners? As mentioned in the paper, we're discussing with the owners. The proposed arrangements are basically the same as those for other monuments, and we're awaiting a reply from the owners. Well, as mentioned in the paper, a written consent has already been submitted to us. Well, it's best for you to be able to reach agreement with the owners. We don't want to have different arrangements for different monuments. Say, certain arrangements for Monument A and other arrangements for monument B, that would not be good. Well, $200,000 mentioned here. Well, usually after restoration, maintenance will have to be conducted. And when will maintenance works be completed? Well, in fact, these are two different heads of costs. By maintenance, we mean minor repair, say, of door locks, etc. Now, these are maintenance items. After a few years, say, depending on the conditions of the buildings, but roughly speaking, in 5 to 6 years' time, we may need to conduct major repair. Then we'll apply for special funds for special repair. So that's not minor maintenance. Next, Mr. Chen Chi-chun. Well, just now, I didn't mention the time for each member. 6 minutes per member initially. Mr. Chen Chi-chun, first of all, I have to say that I respect the monument policy of the government. First, to respect private property ownership, and second, to preserve the original design purpose. Last time, we asked about the opening hours and we queried the validity of the written consent legally. Well, if they're not going to open up the structures, we'll have to think about something else, because they may not welcome outsiders. And then they said they would open up the buildings, and then we asked whether they would renege on their words in future. Say, for the next generation of the family, what if they renege on the written consent? But apparently, paragraph 2D of the paper has not answered the question directly. That is, after they've signed the written consent to open up the structures, what about the legal validity of that written consent? For cleansing and security, well, cleansing, $32,000 per year. That's really value for money, but I really don't know whether that's all. And for guided tours, even more value for money. Why is it that they can do all these so economically? Are all these done manually? Mr. Ming, first of all, legal validity. We've consulted the Secretary for Justice about the written consent. The response from the DOJ was that the written consent is legally valid. But of course, at the end of the day, we have to obtain support from the owners. As for the declaration, we must have strong support from the owners in relation to conservation. Now that the buildings are to be declared monuments, the residence itself cannot be redeveloped, and future repair and maintenance will have to be agreed by the government. And even though the structures are to be open to the public, we need to obtain consent from the owners. We've actually obtained strong support from the owners of Fat Tat Tong. As regards cleansing, security, etc., well, cleansing does not have to be done every day. On the basis of our past experience with other monuments, usually cleansing for 2 to 3 days every week would suffice. And docents should generally be volunteers, but of course we need to give them traveling expenses, but that won't be very costly. Another technical issue. Now, this is the residence of the descendants. Now, what if the descendants have all left the structure, say, on holidays? Then the responsibility of opening up would come under the security guards, right? As there are still residents there, we cannot rely on them to open the doors, close the doors, etc., every day.
後人喺度住，咁佢都唔係要住曬全間屋，係其中個部分啫。咁嗰部分我哋盡量唔會打擾佢嘅。
So one family of the descendants lives there. We try not to disturb their daily living, so only the common parts will be opened up. Mr. Ming, can you be clearer which parts will be opened up and which parts will not be opened up? There are 5 parts in Fataton. In the central part, this is a common area where crops and farming tools are placed. At the front yard, it is also a common area. It used to be a common area too. So the owners agreed that the common parts or common areas will be opened up for public visit. Now, as for which other parts will be opened up too, then we'll have to conduct an investigation. And later this year, we will also arrange a condition survey. And we'll see which parts will be opened up. Which 5 parts? The mention is divided into 5 parts. And for 4 of them, they are really the residences. These parts will not be opened up. Next, Mr. Ma Fong Kwok. Thank you, Chairman. The paper this time is rather detailed. Some colleagues have already raised the questions that I want to raise. Now, you talk about security services. Cost is $94,000 per annum. Is that sufficient? I also saw that there is this written consent from the title owners. But it says here that the detailed arrangement of the opening will be further confirmed with the AMO upon the declaration. So there should be a confirmation when the declaration was made. Has that already been done? Another question is about docent services. Is $20,000 per annum, is that enough? Now, as for the confirmation, we will include the condition that when tourists take photos on site, they will not be prohibited from doing so. What kind of format would that agreement take? Will that be in the form of a memorandum or a formal agreement? Now, as for the opening up arrangement, the consent letter provides a framework. We will have to later confirm the details with the owner. More detailed arrangements have to be involved, and I think we should do this on the basis of mutual understanding. Say tourists may be allowed to take photos, but then there should still be some constraints. Will the visitors be allowed to use flashlights, or will they be able to use tripods and so on and so forth? Will that pose any inconvenience to those living in the place? So that all these have to be considered. I understand all these. I think that should be put in black and white because the government is committing $8 million into the maintenance works. Now, the descendants seem to be very receptive to your idea, but, you know, people may change. So I think it's better to put everything in black and white. Yes, definitely, we would put everything in black and white. Would that be a memorandum of understanding or what? Well, we will do that through our correspondences with the owner to confirm the arrangement. Would that be done before the maintenance works are carried out or the restoration works are carried out? Mr. Ming, in terms of timing, the restoration or maintenance works will last from 2015 to 18. When will that document mentioned by Mr. Ma be ready? And when will the place be opened up? Does it mean that it will not be opened up between 15 and 17? We have already sent a letter to the owner proposing the opening arrangements. So if we get the consent from the owner, then that is confirmed. Now, as to when exactly the building will be opened up, we'll first have to conduct a condition survey of the building to ensure that the building is structurally safe. Maybe that entails urgent repair works before the building can be opened up. Now, in times of maintenance works, the building has to be closed. So it's very likely that the building will be closed between 2015 and 2017. Now, as for the costs for security services and docent services, now for contracting out security services, we'll do it through tender. So actually, the cost was arrived at after some considerations about what the tenderers will put up. So the security services will be provided during the opening hours, i.e. 9 a.m. to 1 p.m. and 2 p.m. to 5 p.m. So as I said, docent services are provided basically by volunteers. So we are giving out subsidy or traveling expenses to the docents. So that won't cost a lot. Mr. Sin Chung Kai. Chairman, I'm concerned whether the documents are legally binding. The AMO colleague said that it's important to get the support of the owner. And you mentioned that there are several families as far as the owners are concerned. I note the annex. I don't have any problem with the parts which are blacked out. But I would like to know whether the building is owned by a number of people. Did only one person sign the written consent? I'm just worried that one person may sign the written consent, but then some other landowners are coming out to say that they are not consenting to the agreement or the document. I want to know whether the government has tried to certify whether the signee to the document manager, whether he has the authority to sign that document. Under the monument declaration system, we have to get the consent of the owner or the concerned owner. So we will seek information from the land registry on who the authorized owner is. Some may be individuals, some may be organizations. Now, for Fat Tong, the owner is Li To Wan Chao, and it has a manager. So the manager, in dealing with all sorts of matters, will seek the consent of the owners, of all the owners. So there are two land titles. One is Li To Wan Chao, and then the other is another group of individuals. So the documents have been signed by both parties. So as far as the arrangement is concerned, we have to seek the consent from both parties. The Li To Wan Chao could not give us an immediate reply because they had to seek the consent of another party as well. So we got the support from the entire clan. I have another question. First, you would declare this as a monument, and then the second part, you have to make arrangements for the opening. Now, for the first part, you have already got their consent, but for the second part, you haven't really got the consent yet, and it's still ongoing. Now, at this stage, we are required to endorse this notice, and what we hope that your proposal will be honored by the owner. But even if they honor or agree to your proposal, would that be a time limit, say 5 years, 10 years, or what? I'm not very clear about the proposals and the document. Does it mean that it will have a permanent effect, or will that be renewed in, say, 5 years or 10 years? When we declared a certain building a monument, then that will be sort of permanent, have a permanent status. But then the owner knows that the monument, the arrangement is permanent, and they will not demolish the building. And in the consent letter, they agree that the building will be opened up. Now, they understand that this is not a requirement under the law, and they are just voluntarily making that undertaking. We might have to make some technical adjustment in the future, say whether the opening hours will be extended or the rest days will be changed to another day of the week. So there may be a possibility that such arrangements may be changed in the future. I want to follow up, Chairman. I want to speak about the two procedures. First is the declaration of the monument, and that will last permanently unless there are some changes in the law in the future. Now, I want to focus on the part on management. I know that the management arrangement has to be endorsed by both sides, and you said that you want to seek the consent or cooperation of the owner. Now, we are spending public money to do maintenance works and to make the necessary opening up arrangements. I want to look at the entire mechanism. All right, now we agree on this opening up time, but then that may change depending on the frequency of the visitors, how many people are visiting. So how will the mechanism work in the future in case variations have to be made? Well, the arrangement this time is similar to that for other monuments. If we need to make changes or the owner raises change proposals, we will have a meeting and try to negotiate and state clearly the reasons for making the changes. And then at that meeting, we'll try to come up with a proposed solution. So the same applies to other monuments. Well, let me put my question this way. The management agreement. Now, I believe that any changes have to be endorsed by both parties. Now, we will have a management agreement, and then we agree that a review will be made, say, in 2 to 3 years' time. Now, perhaps the owner may agree everything at this moment, and then you carry out all the maintenance works, and then suddenly the owner says that he doesn't want to open up. So can we be clearer on the agreement? And I fully agree or understand that cooperation from the other parties is needed, but can we lay out everything clearer in the beginning? We don't have such an arrangement on saying a review in 2 to 5 years' time.
Well, if there are special circumstances, we can make special adjustments. I have to mention in particular that when we talk about costs like those incurred by security services and cleansing services, they are actually not proposed by the owners. It's just that the owners have agreed to opening up the monuments. We have to provide such services for the sake of management. Yes, for the sake of the visitors. Right, for the sake of visitors. In fact, the owners have also paid a very high price because they cannot demolish or redevelop the buildings. The residence will be maintained at its present status. So we'd like to normally maintain the residence. Well, no more members for the first round. Mr. Ming, I'd also like to ask a question. The most important point is protection. We agree that the owners can no longer demolish or redevelop the residence. But at least the government will be paying $8 million for this, probably more. If at any time the owners do not agree to the original arrangements, that is not to open up this monument, do they have the right to do so? And if that is to happen, does the government have any ways and means to continue to open up the monument and the owners cannot renege on their consent? And if they renege on their consent, what else can you do? I have to say that this is not a statutory requirement on the owners. It's just that the owners have signed a written consent. That is actually an undertaking. Oh, yes, but after restoration, what if they do not consent? What follow-up action can the government take? That is, in future, the descendants, say in 2 years' time, renege on their consent, and the government has spent $8 million. What should happen then? Well, the signatories are representative. Oh, yes, what if they renege on the consent? Well, then we have to negotiate. Because in law, they do not have to open up the residence. It's just that the owners agree to conservation, so they've signed this written consent. Well, Mr. Ming, I understand. That means they have the right to renege on their consent, and if that is to happen, there's nothing the government can do. Well, right from day one, you knew that. Well, we have agreed with the owners the opening arrangements, and we sought to open up the monument. And all along, the owners have been supportive. In future, if there are to be changes, then by way of agreements, well, I'm asking, what if they renege on their consent? Well, I think you have two possible solutions. If they renege on their consent, you may go through the legal avenue. That is, you can chase after the signatories of this written consent. If after a number of years they renege on this written consent, the government has the right to follow up on the basis of this written consent. That's number one. Number two, part of this $8 million will be spent on the common areas, but any sums of money to be spent on the 4 portions of the residence, we're talking about maintenance, overall maintenance of the residence, so including the residential areas of the owners. Well, the objective of the maintenance is to allow the residents to continue to serve as a residence and to allow members of the public to enter the residence to appreciate the residence. The residence will not be deserted then, because if it is deserted, it may eventually collapse. So it's a matter of consent. I understand So this $8 million will not just be spent on the areas to be open to the public. Part of that sum of money will be spent on the private portions of the residence. Yes, we're most concerned that just in case in future they are to renege on their consent, to put it in simple terms, you can do nothing. Well, of course, we have to be prepared for the worst. Now, public money is to be spent on this residence. Now, if the residence is not to open up in future, are there ways and means for the government to recover this sum of money? Before you spend the money, will you try to sign legally binding documents, including provisions to allow for the government to recover parts of the costs? Well, there is a statutory requirement for declaring the residence to be a monument, but maintenance is not statutory. But if we declare a building as a monument, we have to spend money on restoration and maintenance works, because we want the monument to exist permanently. So there are certain essential expenditure that is not directly related to the opening up of the monument. In fact, the owners also paid a price. If we look at this matter from another standpoint, that is, the owners have agreed to freezing the development right of this residence, such that the government can do restoration and maintenance to allow the residence to exist permanently. So this is a two-pronged approach. I think we all agree. Mr. Yu Si-wing, well, I now start to understand the $8 million and $200,000 are for restoration and maintenance only. As for the other costs, like those to be spent on security services and cleansing services, is out of the owner's goodwill that they have signed this written consent. In future, they may not carry out the works. So the spending is mainly to preserve this monument so that it will not collapse and can exist permanently. Now, restoration and maintenance are related to the declaration of monuments. Morally, we have to resolve certain issues like garbage clearance, management problems, and so forth. So we need security services and cleansing services, which result from the opening up of the monument. So once the government has signed the agreement, the $200,000 will have to be spent, because we need to have security and cleansing services in order to preserve the monument. So the extra issues like opening up of the monument, etc., we don't have the legal details in this paper. Well, the government is to spend quite a great deal of money on these two monuments, namely $8 million and $200,000 respectively. Well, I understand what you said in the moral sense, but legally, I would like to have more guarantee. Taxpayers will consider the objective of this conservation exercise, because members of the public would like to visit the monuments such that they understand more Hong Kong's culture, and this may also be a tourism attraction. So this is a very important experience. Can we have a supplementary paper on all these? Because you are still negotiating with the owners. We cannot leave everything so vague. In future, they may renege on their words, and they may even argue back that this is a heritage from their ancestors, and the government is disturbing them. All right? After you've resolved the major issues, the younger generations in future may think that the residence is so old-fashioned, they may like to make it more new-fashioned, so they may want to renovate the residence. Can they do so? Well, after the declaration, in accordance with the statutory requirements, the AMO will have to vet the project first before the Bureau Director will sign the consent. Therefore, the owners are giving a very important undertaking because we're talking about statutory protection of the building. In future, even if the descendants are to propose new facilities, they will have to obtain consent from the authorities first before they can do so. So for the sake of conservation, the owners have already given very strong support to us. As for the opening up of the monument, the owners have been adopting a supportive attitude. Otherwise, they didn't have to sign a written consent. Now, the preservation of the building is permanent. And this written consent has been signed by the formal owners and their representatives. In future, we still need the cooperation of the owners. If any adjustment is to be made, then we need to negotiate to see how we can open up the monument in a better manner. Well, let me go back to my first question. We need a legally binding agreement. It may not come under the principal ordinance. We're paying so much money, members of the public will have their expectations, owners may have their own thoughts. So we would like to have a supplementary agreement that is legally binding. That means there are to be undertakings on both sides. Otherwise, if anything is to happen in future, we'll be subject to queries. That is why we don't do something now, or the owners may renege on their consent and argue back. So we should be given at least a validity period. Say, in 5 years' time, the government will be responsible for the costs of security services, cleansing services, docents, etc. From what we heard from Mr. Ming, apparently all these have not been confirmed yet. He only mentioned negotiation. Negotiation and negotiation. You must set our minds at ease. We mentioned the specific arrangements for the opening up of the monument. We've already put forth very specific proposals. It's highly likely that the owners will agree. Of course, we need to have written confirmation on the mode of opening. In fact, there is a clear indication that such will be the opening arrangements. As for the validity period, we did not have this in the past. In the past, we did not decide on any validity period, say 2 years or 5 years. All monuments have remained open throughout. Well, maybe we can reconsider whether we need to negotiate again in 2 years' time, because the owners have not put up a request for reconsideration in 2 or 5 years' time.
Chairman, the administration may be very optimistic now, and after the maintenance works have been completed, and then there may be variations in the situation. So I think if we have a written consent or written communication, then that would be best. What we say today may change in the future. So in that case, I think we should have a supplementary document setting out everything clearly. I think the government should be clear at least on the period for, or the validity period of the management right. Now, I asked this question, what if the owner reneged on his consent, but you don't seem to have an answer to that. Now, if we don't have a paper with legally binding power, then it's open up to all sorts of documents, and the owner may try to get back its management right, cleaning right, and security right. Well, in that case, I don't think the money is well spent. Mr. Sin Chung Kai next. I appreciate the AMO's difficulties. But as I said, it is a private property owned and managed by a manager. I'm not familiar with the clan or the family, but in the family there may be one or two persons who do have the power authority, and when they get old, there may be a change of power, and the old people may step down. Now, I must say again that I'm not familiar with the family, but usually 2 or 3 people in the family have all the say. And it's because they respect the history of their clan, and they are very keen on conserving the building. But then the descendants may have other thoughts. They may like to develop the building. Now, the descendants may also prefer not to open up the building. So there may be all these changes. Now, the government will be spending $8 million. But then if there is argument in the future, what should we do? I don't know whether that applies to other monuments as well. That is, whether there is a management agreement signed for other monuments. Ms. Cole, in the last meeting, we said that the policy is really to conserve the building. When the A&M ordinance was enacted, the primary objective is to really preserve the building. And it is all right if the public can really appreciate the monument from some points outside the building. So whether the monument is going to be opened up is not set out within the ordinance. But we do understand that the public has such aspirations of opening up or visiting the monument. So in the review on our heritage conservation policy, we will look at this point, because under the present ordinance, there is no requirement for, say, the private owners of private buildings to open up the building. So it's all along been done through negotiations between the AMO and the owner regarding the opening up of the monument. So what we can do now is to try to talk as much as possible with the owner, and we get written confirmation from them to arrange for opening up. As to whether a management agreement should be put in place for monuments, for private buildings to be declared monuments, then we'll have to consider that in our review. But under existing policy, we try to negotiate with the owner as much as possible. And all along, there has not been any problem with such an approach. We do understand that members now have this concern, so we will consider that in our review, in the review of our conservation policy, and see how we can do a better job. Mr. Sinjunkai, any further views? It's my turn to raise a question. Two colleagues have already said, or no one will doubt the motive of the government. But then it seems the government has not done a risk assessment. Say if the owner doesn't honor its promise, then there is nothing that the government can do. Now, this is the first time that this a monument is privately owned. In the past, the buildings are owned by, say, a university or a public body. This is the first time when building owned privately is declared a monument. So Ms. Koh said that you don't have a policy on such types of buildings. But does it mean that if you don't have a policy, you can't do it? Now, we are spending huge sums of money on restoration and maintenance works. Can this amount be deemed a loan to the owner because the amount will be spent on the overall maintenance of the building? Now, when I talk about a loan, I don't mean that the government will be asking the owner to repay it, but what I meant is that if the owner is willing to open up the building, then the loan will not be collected. Members know very well that once a building is declared a monument, the building should not be developed, and there should not be any retrofitting of the building. Now, but we don't necessarily have to use public money to do the restoration and maintenance works. In the past, there were buildings which are privately owned where the maintenance costs are borne by the owners themselves. So can you think of administrative arrangement as I suggested? Well, it's like you come and carrying out maintenance works on my building, then I sign an agreement saying that I will open up the building. Then I think that's a reasonable arrangement. Can that be done under the existing policy? In the past, historic buildings owned by private owners, we have a subsidy scheme for the owners for them to carry out repair and maintenance works. But our policy is that we try to preserve historical buildings as much as we can. The monuments usually have high heritage value. Now, I want to stress that we have to strike a balance between protecting private property rights and heritage conservation. The owners, in fact, have to pay a high price. While they can easily demolish the building and redevelop it, but actually not many owners are willing to let their buildings to be declared monuments because they're giving up their right for development. So under the present policy, we want to strike a balance between heritage conservation and development. Now, if the owners are asked to give up their development rights and you are still asking them to shoulder the repair and maintenance costs, then it would be difficult for us to ask the owners to consent to give consent for their buildings to be declared monuments, because the owners have to pay a price. Well, Ms. Cole, I'm not saying that they would be asked to pay a sum of money, but I'm asking that we go by the way of a loan to request them to open up the building. Well, in our repair and maintenance works, we spent all the money in the works, and we don't give any money to the owner. Now, as to whether a building should be opened up, it really depends on the purpose of the building. Well, in fact, for some buildings, they may not be fully opened up. It depends very much on the purposes of the buildings. We try to preserve the buildings as much as possible. The appearance of the buildings do have value in terms of appreciation. So we will not consider my suggestion. Third round, Mr. Yu Si-wing. Because for this building, there are people living there, so there may be a risk. Now, later, the residents may decline or refuse to open up the building. So the members of the public may have this question: why we spent so much money on it when it is not opened up for public appreciation? You are spending $8 million for maintenance works, and then annually $200,000 for maintenance works. And then if you say the building is not going to be opened up, then I don't think it's reasonable. I insist that the owner gives an undertaking for opening up. If we have past precedents, then I think it's okay if we go down that route. But if this is the first case of such a private residence declared a monument, I think we should set a precedent ourselves, and we should be setting out clearly the government's responsibility in management, and then the owner should give clear undertaking of opening up their building, and we should set out all these in a document. But I think this document can give better guarantee. I think this is an opinion. I think today we've said many times that we are worried that the government is not properly safeguarding the use of public money in this case, and there is no guarantee that the opening up arrangement will last sort of permanently. The government doesn't seem to have a policy and is saying no to every and each of our suggestions. Mr. Yu Si-wing, do you have any follow-up questions? I do have a question too. I did ask, would the money be spent first, or would you be getting the consent of the landowner first? I want to be clear about the chronology of events. So we said the opening arrangement will be this and that. So the government will agree with this with the owner first, and then we will issue the tender documents, or what? As for the timing is concerned, we will agree with the owner on the opening arrangement, and then we will do the repair and maintenance works. But these are two separate things, actually. And by carrying out repair and maintenance works, we hope that the building will be structurally safe and can be preserved permanently. As I said, we have sent a letter to the owner, and we are waiting for his reply. If members don't have any questions, and now we have some matters to deal with here. Do we have to scrutinize the notice clause by clause? Yes, let's do that.
不如政府
Well, perhaps we should invite the administration to take us through clause-by-clause scrutiny. Our legal advisor can also advise us. I asked a lot of questions just now, but after we've completed scrutiny of the notice is deemed to have been passed. Well, at the council meeting on the 22nd of February, the notice will be enacted subject to this negative vetting exercise. Well, I don't see any objection to the notice, but how the administration has been handling the matter is problematic. There are still a number of loopholes, and the undertaking for the opening up of the building is not actually guaranteed. We only rely on an undertaking. Ms. Cole told us that the future policy review will look into this matter as well, and the AAB refused to come. There's no way we can further extend the scrutiny period. We've extended that once. So the 22nd of February will be the deadline. I hope that on that occasion, members will enthusiastically speak. So we'll proceed to clause-by-clause scrutiny. And then we have to submit a verbal report to the House Committee on the 7th of February. And if members so consent, we'll go on a site visit. Last time, the administration told us that the owners of Phat Tat Tong were not in Hong Kong, so that would not be possible. What about now? The manager lived overseas, as we mentioned last time, but if we are to go on a site visit, arrangements can be made. All right, arrangements can be made. Before the 16th, we can arrange a site visit. We'll agree on the time after the meeting. All right, so let's proceed with clause-by-clause scrutiny. Mr. Chairman, in fact, the notice is very simple. It is to declare two historical buildings as monuments. One is in 125 Shuttlecock, Phat Tat Tong. Another is Tata Communal Hall at Pingshan. So that's the notice. Yes, it's relatively simple. In the written consent submitted by the owners, 4 lots are included, but those 4 lots are not set out in the notice. Any reason for that? This is related to boundary delineation. The Lands Department's maps have clearly indicated the delineated boundaries. So 1113, 1114, 1115, 1118, and 1119 do not have to be set out in detail in this notice. Well, the DOJ has gone through the notice already. Legal advisor, any advice? Mr. Chairman, concerning the notice, we've gone through it and did not discover any drafting problems. No commencement date is included in the notice. According to Section 20 of Cap 1, this notice is deemed to commence on the gazetted date, that is the 27th of December. Well, the notice itself is very simple. If there are no other comments, the notice is endorsed. If members want to move any amendment, the deadline will be the 19th of February. Mr. Sin Chung Kai. Mr. Chairman, I won't oppose the declaration. At least the Democratic Party will not oppose the notice. But Mr. Chairman, as the chairman of the subcommittee, you should at least, on behalf of the subcommittee, speak on remarks expressed today, and members can follow up. Yes, thank you for this request. The administration has not been able to convince members that the existing administrative arrangements will be able to protect public assets. So the government has to explain. Of course, this is a piece of legislation, but given the existing arrangements of the AMO and the existing policies of the government, members' worries and doubts have not been addressed. But we cannot refuse to pass this notice because it is general public wish that these historical buildings be declared monuments. So meeting adjourned. As for the site visit, the Secretariat will liaise with you. Thank you. The site visit will be open to all LegCo members. Thank you.